The case of Misenga Jones versus the Ghana Elections Commission and others has been unanimously dismissed by the Court of Appeal, and a stay of the effect of the court has been granted for 24 hours. The appeal was dismissed as being frivolous and vexatious and a further abuse of the court. The court ruled that the results of the national recount exercise is to be used to form a declaration of the results of the 2020 elections, while also expressing the view that the Chief Elections Officer, Keith Lowenfield, is a statutory officer of GECOM and therefore should and must adhere to the request and directions of the Elections Commission. In handing down its ruling, the three judges of the court, Justices Priya Sunarayan Bihari, Rishi Prasad, and Don Gregory Barnes, all agreed that a number of matters brought before the court are res judicata, meaning they have already been adjudicated. In handing down her ruling, Justice Bihari stated,
"In the circumstances, I order the appeal dismiss, the cross-appeal of the fourth respondent dismiss. The cross-appeal of the seventh and eighth named respondents is allowed in relation to ground one of the notice by the seventh and eighth respondents of intention to contend that the decision of the court below be varied, and the court's jurisdiction to inquire into the constitutionality of Section 22 of the ELAA, the validity of Order 60 and the recount results are prohibited unless within the parameters of Article 163 of the Constitution."
Speaking to the subject of the Chief Election Officer, Keith Lowenfield, Justice Rishi Prasad pronounced,
"The CEO is duty-bound in the peculiar context of these elections to prepare and present his report based on the results of the recount, as instructed by the chair. There is simply neither power nor authority reposed in him to act otherwise."
Meanwhile, Justice Don Gregory, in upholding the decision of the High Court, stated,
"In my view, the jurisdiction was correctly exercised, subject to my findings in relation to the interpretation aspect, which I have already mentioned. So I would dismiss the appeal, and my full reasons will be incorporated in my written judgment. And so I would dismiss the appeal of the appellant."
The court had also advised the applicant, guided by her team of lawyers, that an election court through an election petition is a better option for treating with the matters brought before the court. The applicant, Misenga Jones, through her attorneys, had filed a case against the Ghana Elections Commission and others, claiming that Order 60 of 2020 is unconstitutional and therefore the results emanating from the national recount exercise could not be deemed as valid. Jones had also contended that the chairperson of the Elections Commission is duty-bound to accept and use reports submitted by the Chief Election Officer based on Article 177(2)(b) of the Constitution of Guyana. The High Court had also recently dismissed these challenges in its ruling, leading the applicant to appeal the case while seeking to have the ruling of the Chief Justice overturned. Wendell Badrie for HGP Nightly News.